We're going to talk for the next 2 or 3 classes about false speech and the extent to which false speech is protected by the First Amendment. And on that subject, I downloaded the transcript of the argument in the Supreme Court yesterday in the Alvarez case, the liar case. It's great entertainment. All of the justices except Clarence Thomas had interesting, provocative questions. And it's a good read, quick read, but you'll need to read it for your paper at some point. I don't think you need it for next week when we'll talk a little bit about Alvarez. And I do intend to post the assignment for the paper sometime in the next week or so. Gives you lots of time. It's not due till middle of April, well after the midterm. So we'll talk about libel today and Tuesday. And you might wonder why we're talking about libel in a course on freedom of speech and the press. And it's because the law of libel is one of the great inhibitors of what is published. Editors and reporters do a lot of worrying about whether they'll get sued for libel if they publish this story, if they publish this information. The law of libel is a creature of the common law. It grew up at common law. All of the rules were established at common law over the centuries. In California, as you see in the reader, there's a statute in the Civil Code, sections 45 and 46 of the California Civil Code, which lay out some of the rules of libel. But if you read the fine print in the statute, you see it was enacted in 1872. Well, what happened in 1872 was there was a reform movement in California to sort of reform the law in all areas, and the powers that be decided that they ought to codify the common law so that it would be easier for people to find out what the law is on any given subject, because it would all be in a statute enacted by the legislature, and you wouldn't have to search through reports of cases decided over the decades before. So the California legislature codified the law of libel, put the rules as they stood in 1872 into the form of a statute. So in California, libel is not entirely a creature of the common law. It's sort of a blend of the two. But as I say, they didn't get all of the rules into the statute, and the rules have evolved since then. So you can't really rely on the statute. For some answers you can, for some you can't. The part of the whole universe of law where libel fits is under the rubric of torts. It's not contract law, it's not administrative law, it's not constitutional law. It's torts, civil wrongs that give rise to a right of people to sue a wrongdoer for the injury caused by the bad act of the wrongdoer. And all kinds of torts. I don't know, there's dozens, must be over 100 torts recognized by the American states. They're all creatures of state law. There aren't any federal torts. The torts would include things like assault, hitting somebody else. It's a tort, maybe a crime too, but it's certainly a tort, and the victim can sue for damages. Negligence, the bread and butter of the courts, automobile accident cases, all involve negligence, where the wrongdoer didn't act as a reasonable person would in the circumstances, causes damage to somebody. That's the tort of negligence. And then defamation is the proper name of the tort that we're going to talk about today and Tuesday. And defamation comes in 2 varieties, libel and slander. Just because it's more convenient, I use libel to cover the whole thing, and most people do. But in fact, libel is different from slander. Libel is basically written defamation, or defamation in some fixed form, whereas slander is oral. And there are differences, and the courts have concerned themselves with defining those differences over the centuries and so on. You don't really need to know the difference between the two, other than libel is written and slander is oral. And it's more difficult for somebody who has been slandered, defamed by something said, to win his or her case than it is to win a libel case. And that's because the rules are more strict for slander. And I think the idea is, well, slander is really not as hurtful, not as injurious as libel, because these words just go off into the ether and they disappear. Whereas libel is something that's written down and fixed, that can be referred to and come back to haunt you for the rest of your life. So that's treated as a little more serious wrong than slander. What's the interest protected by the law of libel? Well, it's the interest in preserving one's reputation. And it's an interest that we all care about to some extent. I mean, I forget who our English majors are here, and I hope you'll correct me if I botch it, but the idea comes up in Othello, where Othello says, "Who steals my purse steals trash, but whoever takes my good name makes me very poor indeed." The idea is that libel injures one's good name, reputation in the community, and that's sufficient injury for the law to provide a legal remedy, a right to sue the libeler for money damages. Well, in order to get into what is libel and what isn't libel, I'd like to use the Dorsey case. Arnold Dorsey is, or was, he may still be alive, he may still be working, I'm not sure. He's sort of a lounge singer in Las Vegas, the kind of guy that sings with his shirt open and women throw their underwear at him. Have you heard of Engelbert Humperdinck? Yeah? What do you know about him?
I don't know if I was particularly sad,
Yeah. He lived in Las Vegas and was a very big deal there. Prominent in the community and a very successful entertainer. But apparently he had an affair with one Kathy Jeter, and they had a child. They never married. Dorsey acknowledged paternity and agreed to pay child support for the little girl, and which he did for several years. And then the mom, Kathy Jeter, went back to court in New York State, the New York Family Court, and made a motion in which she asked for child support payments to be increased and wanted to require Dorsey. It's easier for me to call him by his real name than Engelbert Humperdinck, so I'm going to call him Dorsey. She wanted Dorsey to take out life insurance payable to the little girl, and alleged as the reason why she needed to go back to court and get this greater guarantee of support for the little girl. The reason, she said, was that Dorsey had AIDS and therefore couldn't be expected to stay healthy and live very long. And in her affidavit, her statement filed under oath in court, in family court in New York, she said that he has AIDS-related syndrome and has been treated at Sloan Kettering Hospital in New York. Well, not long after that, the National Enquirer, the tabloid newspaper, celebrity news and gossip, picked up the story from somewhere and did a front-page story with a picture of Dorsey next to the headline, "Mother of his child claims in court Engelbert has AIDS virus." And then the article itself was headlined, "Mom of superstar singer's love child claims in court Engelbert has AIDS virus." I couldn't find a picture of the actual National Enquirer issue with the Dorsey story, but this is what they look like. Ex-lovers tell, well, Ted Kennedy has love child. I don't know what this obsession is with love child, but there it is. And the article that the Enquirer ran quotes Kathy Jetter's affidavit twice, and quotes her in an interview, not in the affidavit, quotes her as saying, "I never would have filed the court papers if I wasn't 100% convinced he has the AIDS virus." And the story in the National Enquirer also quotes a private investigator for Jetter, saying, "Humperdinck is suffering from the AIDS virus. We based that on an intensive investigation of the singer during the past 5 years, and been treated at Sloan Kettering," and so on. The third paragraph of the article says that Dorsey denies that he has AIDS, and the article includes a picture of him that says Engelbert denies that he has the AIDS virus. Well, Dorsey sues the National Enquirer for libel, and we're going to pretend that instead of 1992, when the case was actually decided by the Ninth Circuit Court of Appeals, that it's 1963. I picked that year because it's before the Supreme Court decided New York Times versus Sullivan, and in Sullivan made every libel case a First Amendment case, so that in 1963 there was no Sullivan. Nobody thought the First Amendment protected libel in any way. It was one of the categories of speech that are completely unprotected by the First Amendment in 1963. All that was changed, as we'll talk about on Tuesday, with New York Times versus Sullivan. But before Sullivan, libel was simply a state law, common law concept. And the question for you is, what had to be proved in order for Dorsey to win his case against the National Enquirer? And he had to prove several things. Well, several things had to be proved in order for him to win. What are they? So I recommend that you don't take any notes for a minute. Just think about, what has to be proved for somebody to win a libel suit, Carl? That they knew what? They knew that it was a lie? Can we call that a knowing lie? Okay. Malicious intent? What do you mean by that? It was what? Supposed to be. They meant to cause harm to Dorsey by publishing this. Robert? Are you suggesting that that's one of the elements that has to be proved? And what? It causes harm, and I didn't get the second. It's false. That doesn't have to be knowing, you're saying?
I don't know about the false part, because the Dorsey case, it didn't really hinge on whether these allegations were true. It was just based on the exception in the law where it has to be a guaranteed report of something that was in a court proceeding. And since it was in a court proceeding that Jetter said that he had AIDS, it was okay for the National Enquirer to publish that because it came from that case. They didn't have to prove whether the facts in the case were true or not. They just had to prove that they were fairly conveying what came through in the proceeding.
That sounds like a defense to the libel suit. Is that what you're saying? That
you didn't have to necessarily prove, in that case, you didn't have to prove that what they said was false. You have to prove that it was inaccurately reported from the court proceeding.
okay. Yes. Cause damage. Okay. Is this a refinement on harm, or will any harm do? How does he do that anyway? How does he prove harm to his reputation? Yeah. Yeah. Sean? So what does he do then? He calls a witness who says what? Says this kind of statement, the natural consequence of this kind of statement will cause harm. And what kind of witness? Must be an expert witness who's an expert in something, linguistics, sociology. I don't know what kind.
Well, doesn't natural consequences just make it more easy to play with and say wrong? I feel like that's kind of important phrase.
You want to make it easy. You want the libel law to make it easy to play with, because you want to facilitate lawsuits against publishers who are evil. And should be easily. Well, then why would you want to make it so easy to sue somebody for libel? Don't you believe in free speech? And speech ought to be free unless certain things are proved. And even false speech may have some value. John? Negligence? He has to prove negligence? Okay. There are other things that have to be proved. Wait a minute. Defamation? What do you mean by that? No, it isn't. No. Why is it? Do you mean defamatory? That whatever is said defames someone. It's defamatory. Well, it can be defamatory even though it's not done maliciously, right? It would be just a mistake. Right? But defamatory is an interesting thing to add to the mix, since the tort is defamation. Rachel?
I was going to say, I think it's defining the cause of harm, but I think, like, financial loss, you can prove that's directly a result of.
And he does that by, somebody suggested, evidence. Yeah, nobody comes to his shows anymore, and you compare the income he earned last year before the defamatory statement was published, and the income he earned this year, and the difference might be his damages, if it looks like it was caused by the defamatory statement. Mark?
This might go with financial loss, but you also put like status loss as well. Like if you just have like access to like special clubs or special like facilities in Las Vegas and that's
What about his hurt feelings? I mean, he was mortified when this came out. He was emotional. He suffered emotional distress when this came out. Is he entitled to compensation for anything like that? The answer is yes, but what I want to know is that one of the elements that has to be proved in order for him to prevail, to win his case for libel? Yes? No? What am I supposed to do with this? Yeah, Carl. Has to be believable. That's believable. If it's outrageous, then what? If it's hyperbole, if it's overstatement, wildly, rhetorically wacky, then nobody believes it, then there's no harm. So it has to be a realistic lie, right? Yeah.
Because he's a public figure, the question is going to be harder for him to prove that, because they say because he's already been involved in the public eye and knowledge about him is somewhat public information. That's just what I've heard, like, in my own case, I don't think that's true in the public. That's a little bit.
Yeah, well, it's certainly true. You're one jump ahead of everybody here. It's certainly true that if you're a public figure, that's a vitally important thing to know in a libel case. But at common law, before Sullivan, are you suggesting that if he's a public figure, he can't sue?
No, I'm saying that it's
Or
harder to prove.
what's harder to prove?
It's harder, not to prove it, it's harder to have a case because people could argue, well, you're in the public eye and open up your life.
Hard to know where that fits in. But put it on hold, because it's real important. Tina?
He did bring up privacy in his argument, though. It didn't work out for him. But he tried to say that because the statements came out of family court, he had a right to, I suppose, privacy in that.
He had a right to privacy. So where does that fit in our schema here of...
He hasn't been able to prove that someone wrongfully publicized a private speech.
Well, it's true that the New York family court proceedings were supposed to be secret, private. And that's not unusual to have a family court where the idea is, let's resolve these family disputes in private. The dirty linen doesn't need to be aired in public. We protect the privacy of the individuals who are involved in the dispute by making it a secret proceeding. But the fact that New York family court proceedings were private or secret plays into the same notion you were raising before about whether they had accurately published what happened in court. And is there some other way of describing what that concept is? What is it that gives the National Enquirer a defense to Dorsey's suit? It was privileged. This is one of those really rare situations in which the statute, the California Civil Code, answers the question because it defines libel as a false and unprivileged publication. It's part of the definition of libel is that the statement is unprivileged, not covered by a privilege. And we'll come back to that. So, there's more, yes?